Okay, so I take it that from what I've gathered also you have different exposure to intellectual property. Not everybody has an exposure to intellectual property, and in particular to patents, which will be the exclusive item we will be discussing. So just for me to get an idea and to try to see how far we are as a group, I would like to ask you a question, or to put a question to you. So, you're on the road walking, somebody walks up to you and says, look, I offer you either the unrestricted, unconditional rights to a European patent, that European patent, here it is, or 10,000 in cash, tax-free. What would you do? Okay, we have one very, very, let's say, intuitive answer. Grab the money and run. That is what I hear there. However, is there anybody that would consider taking the patent rights?
It depends on what it is.
Aha, okay. I hear the key word, it depends. What would it depend on, according to your view?
So, any technology that would come out of the patent, is there a market for it?
Okay, so whether the technology that this patent protects, whether there's a market for this technology. So when you can get a share of the pie, let's say. Other factors that you would like to consider before you answer the money?
Timeline, how far through prosecution?
Beg your pardon?
Timelines of how long has it got left on the patent rights, for example?
How long out of the 20 years of a patent lifetime? Okay. I take it that you indirectly mean whether it is very new technology or a technology 10 years ago, which might be obsolete. Okay, especially in the information technology. Yeah, please.
Building on that, I'm not sure if that was part of your point, is how much longer you have to develop something novel with the protected.
You've only got rights for another month.
Yeah.
And then you're going to lose.
Okay, so what's the potential, the innovative potential of this? This is what I hear. Okay, other things? Yep.
If it's an application or if it's been approved already?
But it is a specified European patent.
Oh.
So it's a patent. So it's been granted. But that gives me a good thinking point. It can be granted, but it could be challenged. So I transform your answer into whether there is a pending what? A pending opposition, which is challenging of a European patent, or in general terms, pending litigation in any jurisdiction, which might not be your own one, but might be another one.
Only out of curiosity, does China fall under obligation towards European?
No. European, as we will see, the European patent encompasses up to 40 European states. But not US, not Asia.
No, then I take the 100,000.
Because
all racing like crazy towards
because you can invest them in China. Okay.
I don't understand, but there are people developing loads of things over there. So if we think that's the
I see. I see.
Resistance for it.
Okay. Other views that we haven't heard?
Use this patent to restrict the competitor from doing certain things.
The idea of a patent is exactly that, namely to prevent your competitors from exploiting the protected technology. As David said this morning, the idea is not that the patent gives you the right to exploit the technology, it gives you the right to exclude others from exploiting this technology unless they pay you a license fee, which you have to agree. Okay, other ideas?
Can I have one that is, yes, it's unrestricted and unconditional in terms of its rights, but that doesn't mean lacking responsibility on your part and your level of agency. says nothing about the responsibility you might have if you took this option.
Of course not. No. There are other things that are. If you decide to exploit the patent, then you have to comply with other requirements as well. It's not.
And we don't know what the requirements are in this question.
Some of these we may not know. Yeah. So okay, my point is, first, it's not an easy decision. Maybe you have to think hard before you grab the money and run, or before you take the patent. And second, it needs a lot of information as to the status of this patent. One thing I didn't hear up to now is whether there are licenses given on that patent, and whether there are license fees, obviously, and what is the amount of license fees, because that might be important for you. Okay, so, but you see the idea. The idea is, before you go for the money, you have to think about the patent, and in thinking, you have to take into consideration a lot of different factors that have to do with the use of a patent, the technology it protects, the lifetime remaining, the legal status in different jurisdictions regard to that. Okay, so there are enough things that you have to think about. Okay, now that we got us going on the discussion, I would like to say a few things about the European Patent Office, my previous employer, so that we set the scene, and that you know how the European Patent Office works, what it is and how it functions. David said a few things. I'll say a few things more, so that we have a common body of knowledge on which we can build up. So, these are things that have to do with what is a patent, but you know that already. David has spoken about that. Now, let's look on the issue of patentability. Not everything can be protected with a patent. Some things cannot. And in order for some technical innovation to be protected, it has to be novel. David explained it. Inventive. It has to be non-obvious when we consider it with whatever pre-existed. So it has to have a stroke of genius or inspiration. And it has to be industrially applicable. Now, from a practical point of view, the third condition, you can forget it, because it's almost always given, and we never check it except if some very, let's say, irrealistic application of a perpetuum mobile lands on our desks. So that's practically never the case. So novel, industrially applicable. We will see in the course of our discussion that there are a few other conditions as well. We will see them. Now, some things cannot be patentable, cannot be patented. There are some things that are excluded from patentable subject matter. What might those be? Discoveries, so the discovery of America, you cannot patent it. Scientific theories, the theory of relativity, you cannot patent it, because it's, why? Because it's the property of mankind. You cannot exclude mankind from using the theory of relativity, which has been confirmed in the meantime. Mathematical methods, so you cannot patent an algorithm and prevent others from using that, because it's pure mathematics. Computer programs, we will see what exactly happens, because that will be the focal point of our discussion. Aesthetic creation, you cannot patent a nice photograph or a nice painting, no, or a poem. Artistic creations. Business methods, so things, I will be with you in a second. Commercial things, you cannot patent them. Business method in Europe. In the US and in some other jurisdictions, there are some special conditions, but what I'm talking about applies to Europe, because we're talking about the European context. So business methods not patentable, methods of playing games or performing mental acts. So you cannot patent a method to teach a person Chinese, because it is a pure cognitive thing, it's not a technical thing. It happens exclusively within the brain, so you cannot do that. Or presentation of information. Broadly speaking, these things you cannot patent. Interestingly enough, you see computer programs in there, and then you will ask me, now, what's the point of discussing here? If you cannot patent computer programs, then we can go home. It's not like that. We will see about that. There was a question?
Pretty much related to that. I mean, I understand that mathematical models, they are existent in the nature, so it's sort of like a discovery, so you can't patent it. However, a computer program is, in a way, invention, right? Like one has to write it. It wasn't existing before.
Yeah, right. It's
so
part
why
of
is it
yeah.
not considered for patentability?
Yeah, you're right. Computer programs are programming. The action of programming is part of engineering, so normally it should be considered patentable. Now we have to see that that law, because it is a body of law, that the European Patent Convention. It was made in the 70s, and in the 70s, what we understood under computer programs was totally different than what we understand now. In the 70s, the dominating languages were COBOL and Fortran. I don't know if you're familiar with these are programming languages. And when you wrote a program, you could even read it as a literary work, and you could even understand what it does practically. Nowadays, we have totally different concepts of programming and paradigms of programming. We will see some of them. So take it with a grain of salt. Computer programs, under certain conditions, can be protected. But I would like simply you to realize that some things are not by law, are not patentable subject matter. Okay. There are some other exceptions as well. We talk about exclusions. We just saw the exclusions. These are exceptions. These are the words that the law uses, and it has to do with plant and animal varieties. So you cannot patent a plant or an animal. And some items that if you would use them, it would go against morale or ethics. A typical example there is landmines. So we say landmines is we don't patent them. And methods of treatment of the human or animal body, that has to be taken also with a grain of salt. Practically, a method of surgery that is performed with the hands, you cannot patent it. But you can patent a machine, for instance, that helps do telesurgery, which is controlling the surgery from a distant point in space. So there are legal provisions to that effect as well. Oh. That was David's stuff. What are the other instruments of intellectual property? And okay, just a few words about the European Patent Office. So it is an intergovernmental organization. It is not an EU agency. So the European Patent Office is European, but it does not belong to the context of the European Union, of the Commission, and so on. It's distinct. This means two things. First, we're not 28 member states, we are 38, so we are a superset of the EU. And even if the EU becomes 27 member states in the unlikely event, we will not become 37 because the UK will still belong to the contracting states of the European Patent Convention, because it's distinct from the EU. We are 7,000 people in the office. Headquarters are in Munich. A big branch is in The Hague in the Netherlands, and two smaller branches in Berlin and Vienna. And we have 4,400 examiners. These are scientists who are specialized in a body of knowledge which belongs to one of the three big categories of technology. So mobility, mechatronics, so whatever has to do with engineering, the tangible engineering, chemistry, chemical technology, and ICT, information communication technology, whatever has to do with electronics, software, and these things. So you see that those people are really very, very, they are specialists. They know their technical domain very, very well. And we are self-financed. That means we don't have to go on our knees to the national administrations and beg for money. We operate under free market conditions, and our capital is, our expenditure is covered by the fees that we charge for the services that we offer. That's very important to know. Okay, that's about the EPO. Interesting to know that this is the geographic coverage of the organization today. So we cover 38 states. We have some member states that cooperate with us without being member states of the organization, and we cover a basis of 700 million inhabitants, possible consumers. So protecting an invention via the EPO can, in the maximum case, embrace 700 million possible consumers, which is quite interesting. That much, yeah.
Is the validation state?
I beg your pardon?
What is the blue ones?
That is validation states that are states that have a special agreement with us, so that if the patentee, the owner of the patent, wants to validate this patent on these states, he or she can do that. However, the difference between those and those are that they are not member states of the European Patent Convention. They are not signatories to the convention.
But can they apply for the patent within this organization?
Anybody can apply. The planet can apply for a European patent, because if, for instance, an American would like to protect her invention in Europe, they have two options. Either they go to the national patent offices of those European states that are interesting for them, or they go to the European Patent Office, which with only one procedure can encompass any subset of the states there. It is, if you apply for a European patent, it is your decision in which of these states the patent will be validated later on. You can take any subset, or you can take the whole. It has to do with cost, of course, and it has to do with your commercial objectives. Where would you like to market your invention? So that's our organization. I will skip the promotional stuff and go to the substance. So you have a nice idea, you have an innovation, you want to market it, so you say, okay, I go for a patent. What are the possible ways? You can go to the patent offices of those states that are interesting for you, say UK, Germany, France, Italy, whatever. So all of these states, all of the member states have national patent offices. However, the patents that those national patent offices grant, they have an effect only in the geographical region of that state, not beyond that. David was quite clear about that, I think it was clear. So you can go to these states. The patent will be valid only in that country. And you have, of course, in some of these states to file in the language of that country, obviously. You have the option to go European, then you go to the European Patent Office. You encompass up to 38 states, plus the extension and the validation states. And then you file either in German, English, or French. It is up to you, you choose. And then if you file in English, for instance, the whole procedure will be in English. And you get a patent which will be then valid in those European member states that you decide. or you can go international. There is, however, a fallacy there. There is no a global patent. There is no a world patent. No, there is not a patent that encompasses the planet. That doesn't exist. If you go via the so-called international way, then you go according to another treaty that is called Patent Cooperation Treaty. Maybe you have heard it. It's called PCT, the acronym. And then in PCT, there are up to 152 countries. I think now it's 153. And you don't get a patent, but you get a certificate that gives you, that somehow confirms that if you go to the national patent offices of these countries or to the EPO, you will get a patent. It is a certificate of patentability, but not a patent in strict sense that gives you rights. And as David said, it is also a mechanism to buy some time. Normally, when you do a first filing, let's say you do a first filing in the UK office, you have 12 months to continue with your filing beyond the geographical region of the UK. Why? Because within these 12 months, the filing date of the next step will be as if the filing took place on the date of 12 months ago. That has some implications that are of interest and of advantage to you. And then you have 18 more months, as David indicated, after PCT filing, the second filing, to go national or to go to another patent office, maybe to a regional patent office.
Yeah, sorry, just to confirm something with you. My understanding of what you just said in terms of the PCT, it sounds like it ends up being a kind of retrospective way of elongating the patent to be prior to start before officially the actual patent. Is that correct?
Exactly.
Right.
The PCT gives you 30 months, 12 plus 18,
right,
to think about whether you really want to go, you're serious about that,
yeah.
to find capital, maybe to knock on the door of venture capital companies or of business angels, to see and come to conclusions as to the commercialization of your patent, to probably negotiate with possible licensees, whatever. It's up to your, it's your stuff practically. But you buy 30 months.
Is there a penalty if you went through PCT and decided then, no, I'm not going to go through?
Not at all, not at all. You just have invested some money that will not return, but not at all.
And could you never try to patent the same idea if you'd given up?
Well, that is now a good question, because 18 months after the date of the first filing, there are 18 months of secrecy after the date of first filing. On the 18th month, your application, the technology, will be published. From that point onwards, it can be used against anybody who files a relevant similar application as prior art. It can have a devastating effect. So you have to bear that in mind. It can be used also against you. Okay, so normally people start with a national filing, then they go PCT, and then they go regional or in other national jurisdictions. So that's the normal way. This has the effect that it somehow staggers the cost, and it moves the cost towards a point in time when you're sure, yes, I want to go about it. I'm serious about that. I want to go for it. Here is again those three routes: national, international, PCT, or European. Just to be sure, this is not a prescribed order. The order is up to you. You define the order. You can very well go first to the European Patent Office and do a first filing there. You can apply for a PCT certificate as the first filing. No problem. This is not prescribed. It is up to you to choose. And of course, in order to take such a decision, I guess it is up to you to advise the people according to the circumstances. I would like to say a few words about the procedure. So you knock on the door of the patent office and you do a filing. That means you bring your application there, you file it. After some checks as to formal criteria, so it has to be clearly legible what you presented or such things. Then an examiner within the patent office where you filed does a search. That means the examiner looks into pre-existing similar technology and comes up with a few documents that are similar with what you filed from a technological point of view. Then there is examination, so the examiner compares the two and finds the similarities and differences and reaches, the examiner, a conclusion as to whether your application deserves to be granted. It may be that there is a ping pong of letters between you and the examiner or your attorney and the examiner to amend the application, to bring it in order for grant. And we hope that eventually you get a patent, that is the grant stage. Be aware that 18 months after the filing date, your patent application will be published. And the whole world will know that you filed this patent application on that date, 18 months ago, with that technical content. Is this something you want? You can prevent it if you withdraw the application before the 18 months. Nothing will be published. But if you want to go on, the planet will know after 18 months what you invented. Maybe this is what you want. It will not be a patent yet. It will be, your application will be in the course of examination, because the examination normally lasts longer than the 18 months, okay? And we hope that eventually you get a patent granted, but there is a mechanism to challenge your granted European patent, which is called opposition. If one of your competitors thinks that your patent was granted whereas it shouldn't have been, then she can oppose your patent. And then there is a separate procedure, which is again interactive. But this procedure now has two parties in front of the patent office. The right holder, the patentee, you maybe, and the opponent. And the patent office now has a different role. The role is the role of an umpire, a role of an impartial judge, in quotation marks. And the patent office reaches a conclusion whether the patent was granted or whether the patent should not have been granted, in which case it may be that your patent is revoked. We will see that because we will talk a little more in detail about each one of these steps. But this is a broad, let's say, picture to show you what are the individual steps your application has to go through until you get the granted patent or the confirmed patent after a challenge. Some information about the filing. The filing is checked with regard to some formal requirements. The formal requirements are there, so there must be, the inventor has to be named, there must be a technical description, and the applicant has to provide information to the patent office so that the patent office can contact the applicant, because that if this is not possible, then no communication is possible, then that is not a valid filing. And the milestone at the filing procedure is the filing date. It's the date on which you get a confirmation that on that date, that person, that entity, filed a patent application. That's important. Then we go to search. So our examiners or the examiners of the patent office go into huge databases and they search the technology and they come up with those documents that are relevant. They contain similar technology. Now, if you ask me, how do they search? Now, there is a very sophisticated categorization mechanism for the whole technology. So we have a categorization mechanism. It's based on categories that are called IPC, International Classification, IPC, International Patent Classification. And each part of the technology is categorized with the help of a code, so that when the examiners go to search for this kind of technology, they don't go into a continuum in an amorphous mass. They go in a targeted way. They know what they have to search for. And the outcome of the search is, say, 2, 3, 5 documents which are very, very pertinent, very relevant to the technology that you have invented. And the greater the similarity between the documents and your application, the less the chance that you will get a patent. Because then your patent will be obvious, or your patent application will be obvious to what pre-existed. That lowers the chance of you getting a patent. The less the similarity, the higher the chance. "18 months after the filing date, publication, irrespective of the stage in which your application is." Now the planet knows about your technology. Examination, of course. And the examination has two possible outcomes. Either you get a patent granted, or your patent application is refused because it doesn't fulfill the requirements of the law. Is there any other possibility for you? I'm looking at you because you are you're studying to be European patent attorney. So either your application is granted or it is refused. Is there another possibility for the fate of this application that you can regulate?
You can withdraw.
You can withdraw, exactly. You can withdraw your application. It's up to you. If you withdraw it before the 18 months, nobody will know anything. So it may be the motivation for you to withdraw. You can withdraw at any stage. As long as your application is pending and has not been granted or refused, you can withdraw at any stage. Yep. Good question. Whatever happens after the 18 months, between you as the applicant and the patent office is public. It is published. The letters that you exchange with the examiner are public. They are open to public inspection. So the planet doesn't know only that you have filed an application and that the application is in that stage. The planet also knows what did the examiner write to you and what did you respond to the examiner. All this is, thanks for the question, all this is public. So transparent, totally transparent. Now, you are happy, you got a patent granted, you opened a bottle of champagne. However, you have 1 or 2 or 3 competitors out there who think either that you shouldn't have got the patent, or just because they are naughty or they are mischievous, they want to oppose your patent because they opposed any patent that you get, because they are your competitors. So it can be that you get an opposition. Or maybe you are the competitor. Then you can oppose the patents of your competitors. Now, in that case, from the point in time that the mention of a patent grant has been published in a special publication, there are 9 months within which anybody can file an opposition. So 9 months after the mention of the grant of the patent. If the 9 months lapse and nobody has filed an opposition against your patent, then you are very lucky because you have a very, very strong patent that cannot be challenged anymore centrally with the office, but can be challenged locally at the national jurisdictions. If you are a competitor and you have missed the time the time period of 9 months, but you see that somebody else has filed an opposition, then you can join this opposition, provided that you have been accused that you infringe the patent. So there are many, procedurally seen, there are many, many possibilities. And some statistics, in 27% of opposition decisions, the patent is revoked. So filing an opposition does really offer a realistic chance of revoking the patent of your competitor. The outcome of opposition is threefold. Either the patent is confirmed and the opposition is dismissed, or the patent is revoked, and then you don't have a patent anymore, but you can appeal this decision, or the patent is maintained in an amended form. Amended form normally means the patent gets a little more restricted than the initial scope. That is opposition. If you are confronted with a negative decision, be it either your application has been refused, or your patent has been revoked, or your opposition has been rejected, you can always appeal the second instance. We have a second instance in the office. It's called the Board of Appeals, and you can appeal to that instance. And that instance may revise the decision, reverse the decision of the first instance. Filing an appeal is linked also with formalities and with keeping time limits and, of course, paying fees. But okay, that is something that you would have expected. This is a graphical representation of the whole procedure. What is interesting is that within the applicant stage is what the applicant can do to react to the actions of the office. These are the actions of the office. And this is the information that the public gets. You see that after the publication of the application, everything is public from that point onwards. And of course, you see also a block there, which is observations by third parties. That means that if you are simply a member of the interested public, you're not an applicant, you're not an opponent, you just are Greenpeace, let's say, then you can file observations relevant to any pending procedure, meaning that if you are a competitor and you are aware of a document that should have been taken into consideration during the application, then you can file that document with the patent office, and the patent office has the discretion to take it into consideration or not. The applicant will be informed about this, and if your document is very, very strong, it can influence the proceedings. However, filing the document, if you are not involved in the case, ends your contribution to the case. You're not a party to the case from this point onwards. You can write letters, you can receive letters. So this filing those observations doesn't make you a party to the proceedings. You're out. You hope that it's like a fire and forget missile. You hope that the document will change the mind of the examiner. Okay, so this is how it looks like. And the only thing I would like to say now is with regard to the unitary package. One thing that you have to take into consideration, and I want you to understand it, is that once you get a patent granted, this patent, let's say that you have designated that your patent should be valid in the UK, France, Germany, and Italy. So once you get the patent granted, your patent disintegrates into 4 national patents. That's almost automatic. And from that point onwards, you have 4 national patents, or as many national patents as you have designated, provided that you pay fees in the corresponding jurisdictions. As long as you pay the so-called renewal fees individually in each one of these jurisdictions, your individual national patents which have come out of the European patent will remain valid and will have their legal effect. If you stop to pay fees in one of the countries or in all the countries, your patent will lapse. You don't have a protection anymore. So this is something that I want you to know. So we name the European patent a bundle of patents. It's like a bouquet of up to 38 different national patents. The immediate consequence of that is that the fate of your patent in the UK and France and so on is national. If somebody would like to challenge your patent, this person has to go to the national courts. Why? Because there is no European patent court yet. That doesn't exist. We have, I'll be with you in a second, we have only national courts. Ava?
Do they go to their country's court or to the person's, I mean, which court do they go? If they're from different countries.
I would almost think you're a lawyer if you pose that question. Very good question. There is, assuming that your patent is valid in the UK, Germany, France and Italy, your competitor has a choice of which national court to seize with the case.
And are they different? So they need to study which one is more advantageous to themselves? Oh my God. It's really
Exactly. Not only that, but we have a name for that. We call it forum shopping. Yeah, I mean, depending on the technology and depending on the known case law of the corresponding courts, you as the challenger have to judge which jurisdiction would be most, let's say, advantageous for you. And in many cases, you have the choice between 3 or 4 different jurisdictions. Then you have to study the case law in that specific technology, and then you choose maybe the court of Düsseldorf in Germany, or a UK court. It's called forum shopping, yeah. Because you shop for the forum. Now, you will ask me, okay, did nobody think about creating a European patent court so that we have a more predictable situation? The answer is yes. Unfortunately, creating a patent court that will have jurisdiction for so many member states is not an easy undertaking. And there has been an effort to create a European Union patent court, EU patent court. We call it a unified patent court. But the court doesn't exist yet because we don't have the political consensus within the 28 member states. There have been quite important steps to create what we call the European patent with unitary effect. That would be an alternative to the bundle European patent. So then you don't get a bouquet of 38 patents, you get one single patent that can be challenged in one single court. But this court still has to be created. And the political consensus up to now was strong enough to create the unified granting process, but it was not strong enough to create the unified litigation process. We're not there yet. Interestingly enough, the UK has ratified the UPC, the body of law that creates the patent court, and Germany hasn't ratified yet. So we don't know how this will go on. But nevertheless, there is an effort, a political effort to create this. It's work in process. You would ask me, okay, and then how many patent applications do you have per year? Up to 2017, 165,000, and for 2018, it's 174,000, so there's a continuous increasing tendency. That means that the industry has somehow embraced the idea of the European patent, and it works. They work with that. And we don't talk about European industry, we talk about the industry on the planet, because more than half of the applications in the office have an origin outside Europe. They come from essentially US and Asia, more than half of our applications. And you can see here a few statistics about the origin. So you see the left part, it's a little more than half circle, it's outside Europe. And the red part is Europe. And if you ask me which technology is the most relevant to patenting, it's medical technology at the first place. These data more or less apply also for 2018. And at the second place is digital communication. This is what we will be talking the second part of our talk. But you would have expected that. So computer technology, digital communication is very en vogue. Top applicants, you see their names there. Granted patents, they almost mirror the distribution of the patent applications. Because up to now, in your head, there must be clear demarcation between the notion of a patent application, a pending application that hasn't been granted yet, and a patent. It's something that has been granted and gives you rights. Okay, that's it for the first part. So that was the general part. But I guess that up to now, maybe you do have some questions in your minds.
I have a question. We had this conversation before the start of the session about a scenario. So you have an AI algorithm searching knowledge around, I can't remember the scenario, medical scenario.
Okay.
And they said that we can patent the concept of the algorithm and the use. And if there's a different use, you can even have another patent despite the fact that it's the same algorithm. But algorithm is a software. So I'm now a bit confused. What can because they started by saying
let me say just a few words, and then we will park this question because it will come again when we talk about algorithms. We will go into details into those things. But algorithms, mathematical methods, are not patentable per se. That means that you cannot patent an algorithm that calculates the first 1,000 prime numbers. This is a mathematical thing. Very efficiently. You cannot do that because you cannot withdraw a mathematical algorithm from the general use. It is the property of mankind somehow. However, if you use an algorithm in some technical process, for instance, you use a mathematical algorithm in order to do a cryptographic method. Cryptography and to somehow cipher and decipher a video signal. At the basis of this method, there is a mathematical algorithm. But what you patent is not the algorithm itself, it's the use of this algorithm in a technical context to solve a technical problem. For instance, to do cryptography in a more efficient way. Then this technical use of the algorithm can be patented. It will not preclude the use of the algorithm for other purposes. I won't say more at this point in time because it will come up later as well. But I don't know if this helps you or helps the discussion.
It raises more questions, but if you say it's come up again, then
it will come up, yeah. But suffice it to know that mathematical algorithms themselves are not patentable. However, if you integrate them in a technical solution that solves a technical problem, then you can patent the whole solution. The algorithm is only a small part of it. The algorithm itself is not patented. It's still available for you to use for other technical problems.
But I don't understand the meaning of technical in this instance, as algorithms are starting to write poetry. And this poetry, is that a technical thing because it comes from...
Definitely not. Definitely not.
But it is coming from machine. So what is the meaning of...
That doesn't
as
qualify,
we are doing it?
coming from machine doesn't qualify it automatically as being a technical thing. We will talk about technicality, so we park this as well, because the notion of technicality is really central to what we will be talking about. And on top of that, the big difficulty is that you cannot define technical in a way similar to how you define a mathematical notion. So you approach it not in a deductive way. Technical is that, period. That would be the deductive way. You approach it in an inductive way. That means I give you 10 examples of what we consider technical. Then I give you 10 examples of what we do not consider technical. And then I hope that in your head you will have created a concept of what is considered technical and what is not considered technical. If you see another example, you will be able to categorize it as either technical or non-technical, depending on similarity of this new example with the set of things that we have said are technical, or with the set of things that we have said they are not technical. That is the inductive way. This is how a small young child learns to differentiate cats from dogs. Unfortunately, I don't have a better way to teach it. But if you have studied science, then you are a little more accustomed to think in terms of black-white and in terms of definitions that help you categorize in a digital way, yes, no. But if you have studied law, literature, other things, then you are more accustomed to think in the gray zone. And we are dealing with a gray zone here. We will see some examples.
Could I just build one question on top of that, about grey zones? I was interested to find, you talked about that cognitive things can't be patented. I wondered about things like edtech, so technology that's related to education.
Before I tell you that we have to park this as well, this question, so our parking lot will be quite familiar, full. Cognition has to be differentiated in our approach from perception.
Okay.
We differentiate between perception and cognition. And what is the differentiation that helps us do our job? Perception is whatever has to do with sensory stimuli which come from outside, reach our brain via the different perceptual channels, oral, visual.
Sure.
And cognition is whatever happens then in the brain with these stimuli.
But can you design stimuli to prompt a certain type of cognitive act?
That is exactly the very interesting question. Whether this demarcation line will be somehow full or dotted and have some kind of feedback. Let's park this.
Sure.
It will be discussed afterwards. But why did I mention this clear demarcation line between perception and cognition? Because we have a tendency in the patent office to consider whatever has to do with perception as technical and whatever has to do with cognition as non-technical. That is somehow our basic approach, even if it is perfunctory or it is, how should I say, not epistemologically acceptable, but nevertheless it helps us function as the patent office. We also somehow differentiate between physiological and psychological, and then we have a kind of mapping, physiological perception, psychological cognition. But okay, we park the question. We'll do more about it. So now we shift a little for 20 minutes, then we have a break. And our shift is towards ICT, information communication technology. And we will see what do we do when the application that comes on our desk has a technical content in that kind of technology. Now, you're used to being challenged by me, so you would have accepted a challenge. Think of the way you draw cash from the cash dispenser. You put the card in there, you key in your PIN code, and an authorization process goes on, and luckily you get the money and then you get the card. And that is what existed. Now, an ingenious inventor, confronted with the problem of people getting the money and running, forgetting the card on the cash dispenser, had another idea. She said, let's first give the card and then give the money. Nobody will forget the card like that. So that's the invention. And the idea is, should that be patentable? Interestingly enough, the invention is purely software, because you don't change anything, you just change the program. And you change the order of 2 commands, probably, in the program. So you just reverse those 2 color steps. But do you think something like that should be patentable? Needless to say, it is useful. It saves the bank a lot of money. It saves you a lot of hassle. Running in the bank says, please, 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 I got the money, but you have my card, whatever. Should that be patentable? Should it be a patentable invention? How do you think?
My answer is actually a question to you. So,
Not allowed.
So
Go ahead.
patentability depends on not just the commercial interest, but also the inventiveness, right? So that's a combination of 2 that leads to patentability. So in this case, so for example, can we think of in a case like this, there's a huge commercial impact, but not obvious invention there. So this would take over the precedence over the obvious thing, and then the vice versa.
Yeah, I would relativate a little what you said. You said there is a huge commercial impact, but not real invention. It is disputable whether this is an ingenious idea or an idea that would occur to anybody. If somebody would argue, it could occur to me, why didn't it occur to you in the first place? Or the huge commercial interest, of course, because it saves a lot of resources on both sides. Now, what we say in the office is that the indication of commercial, let's say, success is a secondary indication to patentability, not a primary one. So it doesn't suffice, so to speak. Primarily, you have to have an inventive step. Primarily, you have to have non-obviousness. That is primarily.
What if you could record the fact that you responded to the mistake? What if you could record the situations, video record, audio record, in terms of data, record the amount of times that people forgot their card and what the impact of that might be, and that's how you got from step A to step B of making that change?
Yeah. That could be also a secondary indication. You would simply argue, look how frustrated these people are running into the bank asking us to correct the situation. But that is not an issue of, that is not, the proponent might argue, look at the resources we save. The proponent would camouflage the case with a technical jargon and say, we save resources. Let's say the adversary would say, oh, it's simply a cognitive prosthesis, what you do. It works here. It's a help for absent-minded people. Where do you see the technical contribution?
Isn't this just an edit on, I'm assuming, an original patent of the ATM machine that exists, is owned by someone? Isn't this just kind of an upgrade of that, or an edit of that? I don't see how it's standalone as its own concept.
You could say, yeah, you could say that it is an upgrade or an add-on to the ATM machine, but I bet the original ATM machine patent will have lapsed because
Oh, okay, so
this
there's no
things
one that-
existed 20
So
years
this is
ago.
based on the fact that no
Yeah,
one owns
yeah,
the patent
yeah.
from
So
ATM.
take for granted, for argument's sake, that the only contribution here is the reverse of the two steps and the saving of resources, or the saving of hassle due to absent-minded customers.
So in the talk in the morning, they said that whether or not something is patentable depends on whether or not like a skilled person has an idea like this. So can they show that for 20 years, like a lot of skilled people use the machine, but they haven't thought of this? So
That would be exactly the basis of argumentation, although that would not lead to automatically to conclusion. The patent examiner that would say, no, that's cognitive. On top of that, if a skilled person would be confronted with this problem, then she would immediately reach the conclusion, oh, but there is an easy fix. I simply reverse the two steps. So there would be at least two different objections to that patent application. The first would be an objection of patentable subject matter. Oh, but it's just cognitive. And remember, we said the law forbids to give patents for a cognitive effect. And the second objection, even if the applicant would be able to overcome the first objection of the examiner, would be, okay, but it's obvious. The skilled person would do that as a matter of course. Then the counter-argumentation on the part of the applicant, well, why didn't it happen up to now if it is so obvious? And then you have a kind of, let's say, ping-pong of arguments. May the best win. Okay, well, you see why I confronted you with that. I want you to get going, get thinking on what could software do. So we will be talking about three things, basically. One is, what are the legal provisions? We will go and see the article that says these things are not patentable. We will see how the office puts these provisions to practice. So what is the day-to-day job, day-to-day practice? And then we will go and see some practical advice. And up to now, you wouldn't release me without getting some brain teasers from me. So we'll see some brain teasers as well. See, to try to replicate or simulate the thinking process of the patent examiner. Okay. Oh, this is promotional stuff. Then forget it. It's simply, up to now, you know that our practice is defined by the European Patent Convention, that's the European body of law that we follow, and by the case law of the Board of Appeal, that is our own, the small, let's say, court that we have in the office that deals with appeals from that result out of decisions of the first instance. And our case law and our law are independent from case law or law outside our environment. So whatever happens with the American courts or the German courts is irrelevant for us. Not binding. So we are the European system here. Okay, and since we are in the UK has a fundamental difference in the legal system when compared to the continental system. You know, the continental system more or less is based on civil law, so it has codified law and the courts apply the law, and if you have to have another policy, you have to change the law. And in the US, in UK, US as well, and some other jurisdictions, you have common law. That means you have some characteristics where courts have more authority to influence the law. And there is a doctrine of precedence, so higher courts, by their decisions, bind the lower courts. And if you have to deviate from what has been decided in the higher courts, then you have to have special conditions. You had a question? Okay, so just to set the scene. Then your next question would be, okay, what kind of law do you apply in the European Patent Office? It's basically civil law because we have the European Patent Convention that is codified law. But we do have elements of the common law system. That means that some of the decisions of the Board of Appeals, our own court, are quite authoritative with regard to the practice. They do not apply only to the specific case for which they have been decided, but they have a more global effect. Decisions in software technology, ICT, are typical examples of such decisions which influence the examining practice. Okay, I promised you to show you Article 52 of the European Patent Convention, and says that in order for you to get a patent, what you have presented to us has to be novel, inventive, industrially applicable, and then it's not allowed to be one of the following things, which are excluded from patentability. They will, the legalese shall not be regarded as inventions within the meaning of the EPC. So we say these are not inventions. Discoveries, scientific theories, and mathematical methods, aesthetic creations, and, that is the important thing now, schemes, rules, and methods for performing mental acts, so the cognitive part, playing games, and doing business, so the commercial part, and programs for computers. So programs for computers, I put it in red because I want you to concentrate on that. They do belong, according to the law, to the excluded subject matter. And however, we go now to paragraph 3, last paragraph, and says we exclude these things only if you ask protection for them as such. So if you would present to us the code of a computer program and say, I want to protect this, no, you don't get it, because this is a computer program as such. Then the question would be, what is a computer program not as such? That we will discuss. But I want you first to see the law as it is codified, interestingly enough, in the 70s. Okay. Now, let's think, this from now on is dedicated to software. So we think a little about software. I take it that all of you have been exposed to software, either programming or using programs. So let's think a little about what is software, which is not an easy undertaking, because software can develop a lot of different functionality. You can do a lot of things with software. Okay? For instance, you can control a system that prevents the brakes of a vehicle from, let's say, blocking, the so-called ABS system. You control it with an algorithm. It has a lot of sensors and a lot of different things, but the essential ingredient is an algorithm, is software. Okay? Or you know that when you fly with an airliner, the airliner has a lot of different fuel tanks in the wings, and in order for the flight to be stable, the center of gravity of the airliner at any point in time during flight has to be within prescribed limits. It's not allowed to be too much towards the nose and not too much towards the tail. Otherwise, the flight will be unstable. Or it's not allowed to be too much to the left or to the right. So what happens during flight? The pilot has, the system has a very ingenious algorithm that decides which fuel tank will send fuel to which engine. You can have 3 or 4 engines, so you have to feed them. You're not allowed to exhaust all the fuel from the left wing, because obviously then the flight will be unstable. Interestingly enough, during flight, there is an algorithm that repumps fuel from one tank to the other, because this has to happen as well. Now, this is an algorithm, of course. The algorithm itself is not patentable, but the effect is that by running this algorithm, doing the actions, you preserve the center of gravity of the aircraft within prescribed limits during the whole flight. That in itself is a technical thing. That is a technical problem solved with technical means. It's the pumping, but controlled by an algorithm. And that is a typical case of a technical problem solved by technical means which can be patentable, even if the essential control is by means of a mathematical algorithm. If you can use the same algorithm for another thing, be my guest.
Can you use the same system for another thing or just the algorithm? Could I use it to control 4 motors in a car, or is it the actual the technical thing, or is it the application?
What is protected by such a patent is the technical application. If you would,
Specific.
the specific, yeah. If you would like to use the same algorithm for some other thing, then you can use it. You will not infringe that patent, because that patent is just for the control of a flight of an airliner. It's restricted to that use.
Couldn't you argue it's for transport? I mean, would someone maybe argue that if they wanted to protect? How far can you stretch this?
I see what you mean. You could use it in a vessel, in a sea vessel.
That's what I meant. Yeah, I mean, like how specific? Like, is it just like that only the algorithm is the part that cannot be like recreated? Sorry, that is
No, because you can use the same algorithm in the vessel, and you would not infringe the patent for the aircraft, because the two applications are totally distinct. And I bet you that the form of the algorithm for the vessel would be different. The basic idea would be the same, but the form would be different. It wouldn't be the identical algorithm. But the answer to your question is yes, you can use it. You don't infringe the patent. If you have the patent for the aircraft and somebody uses similar algorithm for a vessel, she doesn't infringe. Except if there is another patent for the vessel. Okay, so here I tried to simply give some examples of what we would consider a technical solution to a technical problem in a straightforward way. So these are positive examples. And here I have some negative examples where we use an algorithm for something that is not a technical problem. For instance, you know what is a pyramid sales scheme? So you sell something to your 5 best friends, and each of them sells it to his or her 5 best friends for a small commission that moves towards the top of the pyramid, which makes the top of the pyramid rich and every other member of the pyramid frustrated. In some jurisdictions, it has been decided to be illegal, in some other not. But you could have an algorithm to do that, and then you could have the ingenious idea, oh, let's go to the European Patent Office and apply for a patent for that. You won't get a patent, because that doesn't solve a technical problem. It solves a financial, business problem. And you've seen in the law that business methods are excluded. Or you have a multiplicity of assets, so you have gold, you have cash, you have real estate, you have anything, and you come up with an algorithm to minimize the tax that you owe to the tax office. You can do that with an algorithm. But that would not be a patentable invention, although it would be effective. It would in fact minimize the amount.
Even if that software is adopted by an entire industry, even in that case, it will be patented?
No, because let's say that popularity of the software or adoption by a wide range of industry is not an indication of non-obviousness or not an indication itself of solving a technical problem. It might be for instance, think of a software that determines the salaries of employees of a company. It can be the same software, we have it, SAP, that has a wide adoption. Everybody used to have SAP. I don't know if they have. It's not patented because it could be that individual elements of this system are technical and those are patented, but a salary system for employees is purely financial. It doesn't solve a technical problem. It's not a technical problem to have your salary on your salary slip every month. Okay, now those cases are positive or negative examples, but they are straightforward. What does it mean? It means that there would be consensus as to categorizing them as technical problems or non-technical problems. But what do we do with a gray zone? There are things, and we will deal with some of them, that are not straightforward, technical or non-technical. So then for this we need an approach, and we need a reliable criterion. And we will see that we find this criterion in so-called technical character. What is technical, what is non-technical. What I wanted you to see here is how do we approach software from an engineering perspective. So we put our engineer's glass and we look at software, and this is what we see. But let's try to approach software from the point of view of the European Patent Convention. So we will put our lawyer's glasses on for the next slide. So let's try to look at software from a legal perspective. And there, I would like you to think with me and follow my thought that software has a property that nothing else has. It's unique and intriguing. And what is this property? With software, you can solve a multiplicity of problems, and they can be both technical problems or non-technical problems. And with software, you can program almost all other items in the exclusion list of Article 52. You have seen that the exclusion list of Article 52 has methods of doing business. You can program them with software. Methods of playing games, you can program them with software. Aesthetic creations, you can do with software aesthetic creations. Mathematical methods, you can program with software mathematical methods. And so on and so on. So, if we would delete computer programs from the exclusion list, then we circumvent all the other exclusions. Because with software, we could realize all of the other exclusions. And if software was not in the exclusion, then all other exclusions fall apart. On the other hand, if we say, is it software? It's not patentable, period. That is not fair as well, because we've seen that with software we can do a lot of things that are technical. So, the two extremes, either saying that everything that is software is patentable, or everything that is software is not patentable, those two extremes don't work. I say again because it's important. If we go the drastic way either of excluding anything that's software or including anything that's software in patentable matter, that doesn't work. So we need something in between, in the gray zone. And this criterion in between, we will see after the coffee, that is the technical character, the notion of technical character, which we can approximate not by a dogmatic definition, but simply by examples, positive, negative examples. Coffee?
Yes. Thank you.
We can